Well, hello and welcome back to my channel. That all finished abruptly. I hope you're all well. Well, I feel like this is a case of day. We've got a lot to talk about. And I am a law student from Melbourne, Australia. It is not Melbourne, as people like to say. Yes, it's Melbourne, but it's not pronounced born. We pronounce it as bin, Melbourne. I bet you that was there's some information that you probably didn't need to know. There have been some new documents filed, and we've got some doozies here. So that's really what we're here for at the moment. What being filed. Thank you to Miss Balls for being all over this. This is how I was alerted to this new documentation. So we have got a proposed order. We have got an affidavit of attorney, which is 116 pages long. We've got a memorandum, and we've got a notice of motion and motions. So there's also a notice of hearing, which we've probably already seen before, but we're going to go through, and you can probably hear the cats behind me. The cat's not very happy either. Isn't very happy about things. Joe in Melbourne. Yeah, Melbourne. Yeah. So this was, I don't know why the background's still doing what it is doing. Hello, short order. How are you? Let's go. We'll just go screen. There we go. It's nighttime here, so let's have that reflective of. So this was up on the 19th. So there was a motion hearing, and that they have to appear. So we go back to here. Oops. My virtual background shut down. Okay. Well, it's interesting. All right. Which means that when I go back to my camera, you're going to see the messy stuff behind me. But I'm sure you'll be able to deal with that. All right. And my baby's I'm cat sitting. I was asked if I would look after a cat temporarily in January, right? So January 2025. And we are now on the last day of September, and said cat is still in my possession. She has sort of made herself at home and is currently the boss. And anyone that has cats know that cats like to think themselves as the boss. So yes, so that's where we are. So I'm not very happy. It's not that I'm not happy. It's just that's where we are at the moment. Okay. So let's look at this 2-page notice of motion and motion. So let's see what it is. So again, this is another motion. This is another $100 that have been paid out. Oh dear, this is a bit of reading here. Okay. All right. So this is a notice of motion to deny temporary injunctions, to strike affidavits and pleadings, and for appropriate sanctions, spoliation of evidence. So now you have a cat, your daughter's cat. No, I don't have my daughter's cat. My daughter's cat's with her. But yes, I've had my daughter's cat, Cece. This one's Patches. Patches is white with brown spots on it. But yes, the boss is in. Yes, you'll hear her. She won't be very happy. She may actually make an appearance at some stage too, because apparently, wherever I am, the cat has to be, right? All right. So to plaintiffs and their attorneys of record, Amber J. Stavik and Jacqueline Nafstas Stavik Law. So there are two. Please take notice on the 17th of October, 2025 at 3 p.m. or as soon thereafter as counsel may be heard before the Honourable Curry Willis, District Court Judge, Wright County District Court. The courtroom, the address, Holston, and without a crystal LLC will move the court for the following relief. Interesting that this was a motion hearing from what I could work out against the injunction. So Now, I haven't seen the response to the motion other than the fact that they are wanting to, they're going to ask the court to deny it. All right. But there's nothing on court file at this stage that I have seen, but maybe they're doing it all in one document. I haven't seen the document yet, so let's have a look. So denial, I'm going to look at this. I want to look at this one. We're going to do some little research as well. Okay, so we want to look at all right, so it says they are wanting denial for temporary injunction for failure to soda civic procedure 6502 and the Dalberg factors. So they put in the Dalberg factor. So here we go. So here too, no temporary injunction shall be granted without notice of motion or an order to show cause to the adverse party. I did do a notice of motion. A temporary injunction may be granted if by affidavit, deposition testimony, or oral testimony it appears that sufficient grounds exist therefore. So in court just means it's filed before or after the commencement of the hearing on motion for temporary injunction. The court may order the trial of action consolidated with the hearing on the motion. And this consolidation is not any evidence received upon a motion for temporary injunction would be admissible at the trial on the merit, becomes part of the trial record and need not be repeated at trial. This position and applied as to preserve any rights parties may have to trial by jury, saying that they have not followed those procedures. Okay. So that's the case law that for failure. So we'll order striking the affidavit in an amber static as insufficient because they are unsworn, and admit declaration required. Now, what I would say, one of the things that we were always is you don't start something unless you're. So if they are wanting to have them look at affidavits that are unsworn, they'd better make. So let's have a look. Court documents, unless specifically required by court, a pleading motion, affidavit, or other document filed with the court of ministerial branch or presented to a judge or judicial officer or other relief is not required to be notarized. Presented to a judge or judicial officer constitutes verification as defined in section without administration and the section that the signature as defined by court rules is affixed immediately below a declaration using substantially following under penalty of perjury that everything I have stated in this document is true and correct. In addition to the signature, the date of signing, and the county and state where the document shall be noted on the document, a person who the document is false in any material respect is guilty of perjury. Okay, so the aim that because we'll have to go back, David. So they're saying that they sworn correctly. All right, order for striking the memorandum of law in support of motion of temporary injunction as legally insufficient because it does not contain the acknowledgement required by Minnesota statute. Let's have a look. Let's have a look at this statute. So this is what we're doing. We are just looking at what these. So we want Minnesota statute subsection. So here is this one, sanctions in civil action. And they said Let's go back here. Sub 5. Okay. So here is the Minnesota statute, sanctions in civil action. So sub of sanctions limitations. A sanction imposed for violation of this section must be limited to what is sufficient to the comparable conduct by others similarly situated. Subject to the limitation paragraph B, the sanction may consist of or include of a non-monetary nature, or if imposed on a motion and warranted for effective deterrent to the movement of some or the reasonable attorney fees and other expenses incurred as a direct response. Monetary sanctions may not be awarded against a represented party for violation of subdivision. Monetary sanctions may not be awarded issues its order show cause before a voluntary dismissal or settlement of claim made by or against the party which is or whose attorney are to be sanctioned. Cutting in and out. Okay. Try this one. Now, is this one better? This is the built-in mic. Tell me if this is any better. Sorry. I think because my virtual background's died, I think because it's very happy at the moment. It is showing that it's doing okay at the moment. So hopefully. All right. So when imposing sanctions, the court shall describe the conduct determined to constitute a violation of this section and explain the basis for sanction imposed. Okay. They're saying as legally insufficient because it does not contain the acknowledgement required. So what was the acknowledgement? I thought the acknowledgement not talking. Okay. Sanctions. Oh, it might be my Wi-Fi. It's probably my. Is that better? Okay. Sanctions against for spoliation, including adverse adverse instruction for failure to preserve and produce the social media specifically in the amended complaint and requested in defendant's discoveries. Say that they've deleted stuff. Such and other relief on the accompanying memorandum of law and the 8th declaration of Jennifer Moore with attached exhibits and records of the court. So there you go. So that is what they're asking for. Okay. So that was very long. So now we've got 23 pages. So I'm going to suggest that you sit down, because this could be, we could be in for a little bit of a ride here. I am assuming that this is the opposition to the motion, so which means that no, I believe that she's saying that they've taken down their social media and therefore they don't have their stuff anymore. I don't know. We may find out now. Amber, they're responding to the motion, so then Amber, M and Robert Shin, and they get to respond again. So whoever brings the motion gets the first, and the other side responds, and then the party that started it gets to finish it. But it's got a little bit because they filed their own motion. So to be honest with you, I think the judge needs to tell both parties to chill and stop filing motions, because all that's happening is and the court's time is increasing. I mean, this now is taken away from what the initial court date was about. Plaintiff's motion for temporary injunction not merely defective. That's not as patient. Shouldn't it be a comma? But they've finished that as a sentence. That's not a complete sentence. Injunction is not merely defective. You can't end a sentence like that. Actually, it's not merely defective. Homo McKay, it is constitutionally impossible. What plaintiffs ask this court to impose is prior restraint, a form of censorship the United Court. Oh, we're already going down the freedom of speech and the freedom of reporting. She's so predictable. So predictable way. But it's not about the fact that it's not about reporting. It's all the other hyperbole that went with it. You can report that the house was raided, etc., and people were taken away, and this is what warrants were for. That's fact. But it's all the hyperbole behind it that is the issue. Anyway, all right. So, all right. Let me get over the fact that that first sentence is not really a sentence. So let me read it again. Plaintiff's motion for temporary injunction is not merely defective. It is constitutionally impossible. What the plaintiffs ask this court to impose is a classic prior restraint. The United States Supreme Court and the least tolerable infringement on the First Amendment's rights. Minnesota courts have been clear. There is the harassment restraining order context. In fact, this very court already denied their prior request for injunctive relief. Nothing has changed. If present motion is weaker, it offers virtually no facts that could satisfy the barest, much less overcome the heavy constitutional position against censorship. The only thing that changed. All right, serious. This motion is not a genuine request for equitable relief. It is a procedural stunt. Plaintiffs file accomplished 3 impermissible ends: to smuggle new evidence of supposed into the record in a transparent attempt to poison defendants pending reconsideration, to distract their own discovery failures and litigation misconduct, and to punish defendants by silencing a journalist. To punish defendants by silencing a journalist. Plaintiffs do not seek an injunction because they know no injunction can exist. They seek leverage. See the tactic for what it is: abusive, unconstitutional gamesmanship in its entirety. Oh, hang on. To smuggle new evidence of supposed malice. Evidence. Now let's talk about smuggling new evidence. Let's talk about the July Los Angeles Times report agents raided the Tujunga, home of Pastor Robert, part of the criminal
investigation into alleged sex trafficking for Labor tied to his Shekinah church. That in more declarations, this raid was not speculation. She put it in. She put it in her last. More put it in her last affidavit. So she's the one that opened. Mama Kay says it's to punish her because she can't keep her mouth trapped. That raid, it was publicly confirmed and covered by national and local media. Who is Robert Sheen? TikTok. LA, Fox 11, Los Angeles, 2025. Nor was it the of federal scrutiny. In contemporaneous California litigation, nor is the federal raids to this litigation either. Let's put it out there. In contemporaneous litigation, plaintiffs moved to stay civil proceedings, admitting they had received grand jury subpoenas and correspondence from the US, acknowledging that the federal investigation concerns the subject matter as civil allegations of sex trafficking, fraud, criminal conduct. Short order says, this is so unhinged. She poisoned the water. She has been the one. Interesting. Are you liking the way that I'm reading it? Hello, Vedandra. Am I doing? I thought read of her stuff. Okay, so they were the ones that opened up the can. And one of the points, if you remember, in the injunction was that to stop speculation, was to stop all the hyper around the narrative of that. Cross defendants ex parte supplementary application for an order to seal documents. Specifically, there exists interest overcoming the right of public access to the record, namely that the subject documents consist of strictly and non-public correspondence with the US Attorney's General. The overriding interest supports the sealing of records. What's got to do with it? Why are we caring about whether the records are sealed in California or not? What are you talking about, Jennifer? The overriding interest will be prejudiced if the records are not sealed. The proposed sealing less restrictive means to exist to achieve the overriding interest. Extingent warrant granting this application because if the requested records are not sealed, cross defendants will face irreparable exposure of grand jury subpoenas and contents of a confidential criminal investigation, as well as being deprived of providing a complete record of evidence of motion to stay this civil procedure. Now, my understanding is that either criminal or civil cases are not necessarily relevant by each case with the evidence, and that the only time you can bring matters or other cases or is at the sentencing or stuff. Supplementary brief in support of plaintiff's request to state, but why doesn't respectfully request the court stay all proceedings in this action or discovery pending conclusion of the ongoing related concerning the same facts in the civil case. No indictment has been issued. California law recognizes that an active criminal investigation standing alone is sufficient to warrant a civil matter. It stays particularly appropriate where here, as the parties face an untenable choice between asserting their Fifth Amendment rights and foregoing meaningful participation in civil and claims and cases. Declaration of D. Gutenberg in support of stay supplementary brief. Is anyone confused? Like, what's the relevance of this? Oh, really? It's doing it again? I think it's my internet. I'm sorry, people. I'll close a few windows. Maybe it's because I've got too many windows up open. See what I can do. I'm sorry about that. That's why I've got it in big letters as well, just so that you can
it's better, in the hope that you can at least read it. What has this got to do with the price of spaghetti? What does this have to do with anything?
Anybody can help me out with this. They can tell me what on earth is going on. I'll try that. So
I've just increased the, I've made Sean. All right. Declaration D. All right. A court sealing an aforementioned record, the current grand jury. So essentially, whatever happened in California, they wanted it all sealed because they didn't. The people talking about it. Hopefully this is going to be better. Okay. Now, here's the very next line, which says, yet now insist it is false. They are under investigation. Both positions cannot be true. Their willingness to reach federal subpoenas in California, buying them in Minnesota reveals not confusion, but they seek to suppress accurate reporting when it suits their procedural aims. It wasn't the fact. All right. Plaintiff's motion for temporary injunction is remarkable to contain. Nowhere do plaintiffs identify the press are false. Instead, they rely on sweeping characterization. Defendants accuse them of sex trafficking, fraud, forced labor, and other conduct. That defendants misread this court's ruling, and defendants or forged documents. They are not quotations. They are paraphrased. Plaintiffs cite sprawling 90-minute video media streams without specifying, without identifying passages they claim are objectable. They go through hours of guess what the plaintiffs find offensive, not the law. In defamation, liability turns a whole in context. Minor variations don't change the gist. Without them, the court cannot evaluate whether the statements are factual asserted opinions, rhetorical hyperbole, or substantially true. I thought they actually talked about to be offensive. But have we been reading, looking at different things? Because I thought they did the bits that they said they were to. Right. The problem runs deeper than a lack of specificity, more than the conclusionary claim that no charges have been filed. Neither establishes the falsity nor disproves the existence of an investigation already documented, confirmed in plaintiff's own California filings. At the same time, I think I just keep getting the thing to say that my internet keeps cutting out, so I apologize for that. At the same time, plaintiffs admit contrary sworn admissions from those California proceedings, admissions that directly undermine their narrative here. Plaintiffs also distort the nature of the commentary they seek to join. They argue defendants accuse them of forging documents and coaching witnesses. In reality, the forged documents references were criticisms of plaintiffs' litigation conduct, specifically their repeated practice, both here and in California, of submitting documents under plaintiff's signature that are neither sworn nor wet ink executed. This is a procedural defect, criminal forgery. Likewise, Paulson's commentary on witness coaching was based on deposition testimony, public record, and on her first-hand observations. Plaintiff's attempt at criticism as false criminal accusations exemplifies their strategy. They conflate legitimate conduct with defamatory allegations of misconduct, hoping the court will not notice the difference. In short, plaintiff's evidentiary presentation falls into three categories: conclusionary paraphrases that fail to statements at issue. My internet's starting to annoy me. Reputational complaints unmoored from any specific July to August 2025 post. Admissions of contrary sworn admissions confirming the existence of a federal investigation. None of these categories supply a basis for injunctive relief. Together, they confirm that this motion is not grounded in fact. It is grounded in contradiction, omission, and strategy. So that's we're 5 pages down at the moment. So what are you thinking of? Are you enjoying the reading of it? The dramatic reading? As I said, I thought that they did actually do all of that stuff. They did state that they talked about the post, and then they said it. But as I said, the Keller stuff and the particularly the raids. Your sound keeps cutting off every. I'm really. Yeah, it's all very interesting, isn't it? I just don't know. I have to give points for drama. Giving points for drama. Okay. Let's keep going. Plaintiffs seek a prior restraint on the First Amendment flatly a bit for bit. So they're trying to say they've got First Amendment rights, that she can say whatever she likes about anybody because she's protected by the First Amendment, because now she's back to being a journalist again. We're back being a journalist again. Yep, we're a journalist again. Okay. So plaintiffs are asking this court to do one thing the Constitution most: silence a critic before trial. Court has called prior restraints the most serious and least tolerable infringement on First Amendment rights. Its own history gave right. Interesting that they've put a year in brackets. They obviously don't know what the year is. This state attempted to shutter a newspaper. Near versus Minnesota, this state attempted to shutter a newspaper that had accused public officials of corruption, the statutes, and scandalous publications. The United States Supreme Court struck it down in ringing terms, holding that no matter how distasteful the speech, courts may not muzzle it in advance. The principle has remained unchanged for nearly a century. Government cannot gag a speaker before the words are spoken. Yet that is precisely what the plaintiffs demand here. They do not disguise it. They ask for an order for being at all about them on matters of undeniable public concern. No narrowing, no tailoring, no acknowledgement of constitutional limit, order of silence. And plaintiffs know that they are not entitled to this relief because this court fronted this identical request. In 2022, plaintiffs sought a temporary injunction to silence defendants' reporting. The court denied that motion, and rightly so. Minnesota courts have never permitted a prior restraint outside the narrow order context, and they certainly never censored a journalist covering matters of public controversy. But she's not a journalist. Aware of that precedent. They lost this argument once. Their choice to recycle it now, stripped even of the minimal they offered last time, confirms that this motion is not a genuine bid for equitable relief, but a tactical maneuver designed to burden their opponents and this court. Furthermore, the lack of factual support striking. Plaintiffs have not even tried to satisfy the Dahlberg factors that govern injunctions in Minnesota. Success on the merits. They do not show irreparable harm because reputational injury is compensable, if at all, through damages, not injunction. They do not weigh the balance of harms, which here tips decisively against silence in speech. They do not explain how the court could possibly enforce such an order without becoming a line-by-line sense. Plaintiffs simply leap past these requirements and demand one remedy our law will not allow. This is not oversight. This is a tactic. Plaintiffs know they cannot obtain an injunction. They're not to win, but to punish defendants and plant improper malice in the record. The Constitution does not permit it, and this court should not. There we go. Right. So they're saying the plaintiffs cannot satisfy the Dahlberg factors. Talk about drama, hey? Dramatic. Closed it down. That shows you how much I was interested in it. Whoops. See what I mean about the garbage behind me? We'll go back to this. Okay, that's even bigger now, so you should be able to read. All right. We got up to point 2. Yeah, and I really, 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 really apologize. All right, so we've done that. Minnesota law makes clear the injunctive release is an extraordinary as a matter of right. Dalberg Brothers, Inc. versus Board. To obtain such relief, the movement must carry a heavy burden of establishing each of the 5 Dalberg factors. The nature and the background of the relationship of the by the parties if the injunction is granted or denied. We all have that one room where we put our things in. I know Vedandra, that's mine. The likelihood of success, merits, public policy considerations, and the administrative burdens that would be envisioned. Courts are instructed to apply these factors with particular caution where speech is involved, because the First Amendment absolute bar against prior restraint. The Supreme Court describes such restraints as the most serious infringement on the First Amendment rights. Measured against this framework, plaintiff's motions does not merely falter, it collapses. Virtually no attempt to address the Dalberg factors. They are legal authority authorising the remedy they seek, record that could justify gagging a journalist on matters of public concern. Oh, we're back to journalist again. The omission is telling. Plaintiffs notes them. Their motion is not about satisfying the law, but about sidestepping it. Back to being a journalist again in this. Likelihood success not show any likelihood on success of merits because they do not even apply correct legal standard. The law is clear. Public figure plaintiffs must prove actual malice, meaning publication with falsity or reckless disregard of the truth. Ill will, even a desire to harm, are irrelevant. Even recklessness requires subjective awareness of probable falsity. Plaintiffs ignore controlling precedent. Their motion is riddled with references to defendants' malicious tone, their persistence in criticising, refusal to stop reporting. That is common law malice. Repeatedly warned that mixing the two is fatal. That's a really interesting play on words. Minnesota courts have repeatedly warned that mixing up the two is, even if plaintiffs could articulate the correct standard, they cannot meet it. The record is full of online commentary, opinion, rhetorical shorthand, and hyperbole. The kind of speech Minnesota courts have consistently protected. Hello, Clammy. Plaintiffs' failure to engage with the actual malice standard underscores why they cannot prevail on merits and why their injunction must be denied. It's a very interesting use of term to say that mixing common law malice and is fatal. All right. Threat of irreparable harm. It's also fatal. They alleged reputational injury, but reputational injury, paradigmatic harm addressed by damages. Not if plaintiff prevail, jury can award damages. That is the remedy the Lord provides. The Lord provides, not the Lord. The law. What the law does not provide is censorship in advance. Nearly a century ago, the United States Supreme Court struck down Minnesota's attempt to enjoy scandalous publications, holding that prior restraints are the essence of censorship. Plaintiffs' discomfort of being criticised, even harshly, is not irreparable harm. If the embarrassment were enough, every defamation plaintiff would be entitled to gag their opponent pre-trial. The Constitution forbids it. Plaintiffs' own conduct belies a claim of urgency or irreparable. They have tolerated years of reporting without redactions or corrections. Only now, with summary judgment reconsideration pending, they suddenly point to a handful of July to August 2025 cases for emergency relief. Delay is fatal to claims of urgency that materializes only when convenient for motion practice. Plaintiff's motion is tactical rather than remedial. The use of the word fatal is interesting. there was something else that, I was going to say most lawyers will actually tell their clients to not speak about anything, like, particularly where it's to do with public figures. They will often say, don't say a word, don't talk about it, refer. That's why in some court cases that do all the talking and not the people, because the lawyers know the words to say. That won't get them in eye. You have lawyers to do your talking. Very few cases have I seen where, I've never seen the amount of on there for a civil case. Normally, it's silence, and that is generally because the more damage. I'm surprised they don't just postpone the trial due to investigations since up with his criminal conviction. Well, that's what they've done in California. They haven't done anything in Minnesota. But generally, civil and criminal trials can exist, in isolation. You can refer to outcomes and you can submit evidence from, but they lists. Yes, sorry about that. The balance of harms is not close. Plaintiffs can complain of reputational discomfort and sanctionable by damages. I guess at the end of the day, what she's saying is that at the end of the day, that's what they're saying here. They would much rather pay money than be quiet. Defendants face the most serious constitutional injury imaginable, a gag order forbidding them to speak on matters of public concern, repairable and permanent. Plaintiffs chose to file this high-profile defamation lawsuit. They place their reputations squarely at issue. They cannot now demand immunity from the very day provoked. The First Amendment does not permit litigants to use defamation suits as a sword and weighs entirely against censorship. And also, let's not forget that this is 7M and the Derricks in the raids again, and she kind of it's very interesting. It's going to be very interesting. I'm glad I'm not the judge that's having to listen to all this, because this is giving me a headache, and I reckon yes, as the judge, I'd be telling them both sides to. She has no idea of subjects she could cover beside. It's not even about. You can report on the fact that there was a raid. Okay, that's not the issue. That she went on all these channels and she said she's referred to herself as the expert. She's implied that she was a victim, that she's in posts where she's implied that she's the victim of Shin, and she's implied, and so there's all these other things that are implied. That is the of the fact is not the issue. It's all the other stuff. Public policy decisively favours denial. The First Amendment protects. There's a whole murder thing that's just much more intense at the moment. Yeah. And I heard that. Oh, look, there's a lot more interesting thing. Anyway. The First Amendment protects not just the right of defendants to speak, but also the right of the public. Allegations of trafficking, cult control, and financial exploitation, and matters of undeniable public concern. Plaintiff's motion seeks to suppress the debate as the chilling effect of defamation claims on public discussion. The United States Supreme Court has been equally clear that restraints on speech must be narrowly relative governmental interests. The United States Supreme Court has been equally clear that restraints on speech must be narrowly tailored to serve a compelling interest. Plaintiffs do not identify any governmental soda cases illustrate the same point. Rejecting defamation claim where statements were protected opinion. But the thing is, right? Here's the other thing. Hasn't filed she used journalistic. She's only used the defense of journalistic privilege. She's not actually pled in her defense protected opinion. While not precedental, demonstrates that Minnesota courts continue to enforce strong on defamation claims. Support gagging journalists. She's not a journalist. It supports robust debate on matters of public concern and vigilance against prior restraints. So as I said, she's pleading the journalist line. Finally, the plaintiff's request would impose them. They asked this court to police every video, every social media post, every caption, every hashtag. That is not a judicial function. It is censorship. No, that's what the lawyers are for. It would be the responsibility of her. This court cannot and should not become the plaintiff's speech monitor. The Minnesota precedent rejects it. Plaintiffs have not carried their burden under Dalberg. They have not even tried discussion of governing facts. No attempt to reconcile their request with controlling First Amendment authority, and no evidence that could justify the extraordinary relief. The silence speaks volumes. The law is clear. Injunctions are extraordinary remedies, never granted as a matter of right. Amendment is implicated. The standard is even higher. Prior restraints are the most serious and least tolerable infringement of plaintiffs do not come close to clearing that bar. Every factor forecloses relief. They cannot show a likelihood of success because they confuse common law malice with. They cannot show irreparable harm because reputational injury is compensable with damages. They cannot tip the balance of harms because no amount of discomfort to them can outweigh the unconstitutional silencing of a journalist. Again, if she's not a journalist, can she be silenced? They cannot invoke public policy because the policy of this state and nation is to protect, not censor, speech on matters of public concern. And they cannot propose an administrative injunction because what they ask to police every utterance defendants make, it's impossible. Well, not even her lawyers can police what she says. So at bottom, plaintiffs do not seek an injunction because they expect to obtain one. What does that mean? At bottom, plaintiffs do not seek an injunction because they expect to obtain one. They seek it because they hope to intimidate their critics, to drive up costs and inject inflammatory rhetoric about that. The court should not permit that abuse. Plaintiffs lost this argument once already in 2022 when this court their first motion for injunctive relief. They returned with even less factual support. Their recycled motion is not a serious bid for equitable and active harassment through litigations. Finally, defendants note that any injunction against speech for the most serious kind, should this court grant, will seek immediate review, including relief by writ of prohibition if necessary. So here we've said if it goes through, they're gonna fight it anyway. Yeah, at bottom. Fat balls, they make the rock and world go round. I would have thought in conclusion, or finally, plaintiffs do not seek. Finally, at bottom. For these reasons, the motion must be denied in its entirety. So here's a question for you. Is this bit that I've highlighted, is this a bit of a threat to the... Should this court grant the plaintiff's motion, defendants will seek immediate review, including relief by writ of petition if necessary. So what they're saying to the judge is that if you grant this, we're going to do X, Y, Z. So therefore, you shouldn't grant it. At bottom. Unbelievable. Anyway, plaintiff's retention is improper. Plaintiffs are not seeking an injunction because they believe one is available. They know already denied the same request in 2022. No Minnesota authority authorizes a prior outside the harassment restraining order context. Maybe they just file a harassment order. Rather, plaintiffs bring this motion for 3 which have anything to do with equitable relief. Haven't we read this? First, plaintiffs seek to smuggle evidence of malice into the record. This is a centerpiece, and it is improper. Plaintiffs know that they are barred by Minnesota General Rule Practice 115.11 by introducing new factual material. But in your last affidavit, you started it. They finished, they continued. In connection to a summary judgment. So let's go here. This is the rules. See, here's the thing, right? I'm just trying to say, so they've quoted this rule, 115.11. So this is rule 115 for 11 motions. To be request to make note. Where is it in that rule that says this is interesting? Motions for reconsideration play a very limited role in civil practice and should be approached sparingly. It is not appropriate, however, as they occasionally serve a helpful purpose for the courts. Counsel should understand that although the courts may have the power to reconsider decisions, they rarely will exercise it. They are only likely to do so where intervening legal development, enactment of an applicable statute, or issuance of a dispositive court decision, or palpably wrong in some respect. Motions for reconsideration are not opportunities for presentation of when the prior motion was considered. Motion for reconsideration will be not allowed to on appeal. Most important, counsel should remember that a motion for reconsider any time periods or deadlines, including the time to appeal. Yeah, I know it's very small on this page. Make it bigger. So it says it in there anyway. But it's interesting. It says that they will rarely reconsider. Now, and don't forget to introduce the information regarding the rate consideration. The only way around that is to disguise the same evidence as a part of the injunction request is that of a disguise. But the malice plaintiffs invoked in New York Times versus actual malice means publishing with knowledge of factual or reckless disregard for truth. It does not mean ill. Minnesota courts have made the distinction explicit. Common law malice is not the test. Plaintiffs know this. They have cited these very cases in prior briefing. Their continued insistence of treating defendants' criticism, persistence, and hostility as malice is therefore not a mistake. It's a tactic. Plaintiffs misuse the word precisely to prove actual malice. They hope that by repeating malicious often enough, that the court will confuse constitutionally protected opinions and feelings with the stringent standard that governs public figure plaintiffs. That manoeuvre is improper for two reasons. First, material into the record that plaintiffs otherwise offer under the rules. Second, it attempts to lower the bar, Congress, and the Supreme Court by collapsing the constitutional standard in every one that would make every sharp-tongued critic into a defamation. Plaintiffs cannot change the law by rhetorical sleight of hand. Their misuse of the malice standard is not advocacy, it is gamesmanship. It underscores bad faith on the plaintiff's bad faith is further underscored by their irreconcilable positions in different courts. In this court, they insist it is false and defamatory to report that they are contemporaneous filings in California. Plaintiffs admitted receiving federal and jury subpoenas and acknowledged correspondence from the U.S. Attorney's Office reflecting an active investigation. Both positions cannot be true. That contradiction confirms this motion is not grounded in fact, but deployed as a weapon to mislead this court and suppress commentary. Plaintiffs know to be accurate. But the raids or anything don't have anything to do with this. What they have stated, I don't believe they ever said, what they said was it was the hyperbole around it that was the issue, not the initial factual reporting. As I said, if it was just the factual reporting, there were some raids, XYZ. No, and don't forget, she was saying, "Oh, Robert, I'm not going to stop until his, justice is served," and all of that sort of stuff. Is that factual reporting? KJ is the queen of. So, second, plaintiffs hope to deflect attention from their own litigation misconduct is replete with discovery failures, evasive deposition testimony, and incomplete productions. Plaintiffs have been stonewalled, withheld, and deleted evidence central to this case. When pressed, they respond with rhetoric rather than compliance. Instead of answering for their own failures, plaintiffs attempt to turn the spotlight on defendants. That framing is not only irrelevant under law, but also calculated to distract the court from the real problem, regard for their discovery obligations, and their willingness to manipulate the record. Or a plaintiff delete social media accounts in the middle of a defamation case, submit defective affidavits, blank designate everything attorney's eyes only when criticised. Plaintiff's conduct, not defendant's commentary, is what warrants scrutiny. Is nothing more than a smokescreen of misconduct. Mummy Kay, she knows everything about deleting it. I thought that was a very interesting line. she should have used the Alex Jones Tucker Carlson defense, and it was all independent. Well, as I said, she hasn't. The only she's a journalist, but she keeps changing whether she's a journalist, a blogger through each of these filings. So we're back to a journalist again. This motion is not designed to win. It is designed to wound. So that an injunction is categorically unavailable in this context. This court has already told them so. Yet, because even a doomed motion forces defendants to spend time, money, and energy fighting for the rights of the Constitution already guarantees them. That is the very definition of harassment through litigation. The chilling effect is legal. Defendants are journalists. Oh, we've now had a definitive. Well, here's the thing: is that defendants are journalists. The threat of a gag order, even one that cannot survive appellate review over every article, every video, every post. Plaintiffs know this. The goal is not to vindicate truth in the courtroom, but to silence criticism in the public square. And the economic effect is just as corrosive. Each baseless motion multiplies costs, draining resources that should be spent litigating the merits. This is clearly an abuse. Plaintiffs are attempting to achieve through procedure what they cannot achieve through law, silencing the critic. Conclusion on strategic motives. Taken together, plaintiffs' three motives reveal exactly what this motion is: an act of litigation abuse, not request for an equitable relief. They have tried to smuggle, we've used the word smuggle again. They have tried to smuggle improper malice allegations, hoping to contaminate defendants' reconsideration motion that is legally irrelevant. You know if it was a post or two, dozens of posts, moron, says Mama Kay. They have used the motion as a smokescreen to deflect attention from their own discovery failures and misconduct. Oh, we're back. And they have wielded it as a weapon to silence a journalist and to bleed her resources through repeated merit filings. None of these objectives are legitimate. All of them are improper. The court has already rejected plaintiffs' bid for a prior. They return with even less factual support and even more nakedly. Sorry. And even more nakedly strategic aims should give this court no pause in rejecting it again. This motion is not about protecting reputation. It is about punishing speech. It is about eroding the First Amendment by repetition, and hoping that if they ask often enough that the Constitution says no, the court should deny the motion in its entirety and make clear that this kind of abuse will not be tolerated. All right. We're at page 14 of 23, by the way. Are you enjoying the dramatic reading, though? Just tell me whether you're enjoying the reading of it. All right. Reservation of rights regarding fees and sanctions. Defendants recognise that this is not the forum for a separate motion. At the same time, plaintiffs' conduct in bringing this motion cannot pass without comment. The request for an injunction is foreclosed by controlling precedents. Plaintiffs have already had this relief denied once by this court. They offer no factual showing under Dalberg and no legal basis for improper restraint on speech. Their decision and record bar them raises serious concern about improper purpose. You think ChatGPT wrote it, Mama Kay? I'm going to be very interested to see her. I can't wait to see Amber's response to this. Defendants respectfully reserve all rights to seek recovery of attorney's fees and costs incurred in responding to this motion, and to seek sanctions if plaintiffs persist in pursuing forbidden. Authorise sanctions for filings made for an improper purpose, cause unnecessary delay, or needlessly increase the cost of litigation. At a minimum, court should take note that plaintiff's tactics in filing a recycled motion has imposed unnecessary expense and burden on both the defendant. I want an injunction. I want relief to improper and non-affidavits. In support of their motion for temporary injunction, plaintiffs submitted affidavits from Miranda Derrick, James Derrick, and Robert Shin and their counsel, Amber. One of these affidavits is procedurally defective and must be stricken. Now, I'm going to say to you that she needs to be ruled, because if you start saying that their affidavits aren't correct, they're going to now scrutinise all the filed affidavits from them, and it could be a case of for the same thing. You just will be very careful. You've got to make sure that your house is properly in order. Minister, an unsworn declaration to substitute for an affidavit only if it is subscribed as true under the penalty of perjury and date substantially following the form. So that Minnesota law requires strict compliance with affidavit and declaration requirements. An unsworn declaration includes the statutory perjury clause. I can't wait how Amber sues her for defamation and to see how she spins it when she loses. Courts may consider only competent evidence presented by affidavits, depositions, answers to interrogatories. Unsworn or uncertified statements are legally nullity. Unsworn statements and emails constituting inadmissible hearsay could not be considered. Rule 56 requires affidavits or declarations sworn. None of the affidavits submitted by plaintiffs contain the required under penalty of perjury language. They are not notarized and they're not sworn. They are not competent evidence in support of injunction relief. Just rely on the affidavit of Amber Stavik to introduce dozens of exhibits, but the document is neither a valid affidavit or a valid unsworn declaration. It contains no notarial jurat and admits of perjury clause required by the statute. Without either forms of attestation, the filing is a legal nullity. Because counsel's definitive submission provides no one foundation for the attached exhibits, those materials cannot be considered by the court. Now, I do know sometimes when things are filed electronically that sometimes they do put, again, this sometimes happens in Australia, that sometimes they will allow unsworn ones and they will submit the sworn ones personally. That does happen. I've seen that happen. But as I said, even apart from their procedural defects under the statutes, plaintiff's affidavit had nothing but substance. At most, they assert. Though true, the fact does not establish falsity, does not prove malice, and does not support irreparable harm. Really meaningless in the context of a defamation injunction. Affidavit, no facts, materials to the controlling standards cannot carry the heavy burden required for extraordinary relief. Wasn't the fact that they were saying that that no charges had been filed was against some of the posts where she said that he was going to be arrested or he had been arrested or something like that? Defendants respectfully request that this court strike the entirety of Derrick, James Derrick, Robert Shin, and Amber Stavik as non-compliant. Without competent affidavits, plaintiff's motion is unsupported and must be denied. Be very interesting to see whether Jennifer Moore's affidavit is compliant. That will be interesting. Wouldn't it be ironic? If hers were then? That would be quite amazing, wouldn't it? Let's go to here. And it's pouring with rain here. She has put so I'm going to look, she has actually put, I declare, so she has put that. So at least they're correct there. All right, it's raining quite hard here, so you might hear the rain. Minnesota law recognizes that spoliation, the destruction of relevant evidence, undermines the truth-seeking function of litigation sanctions ranging from evidentiary remedies to dismissal. Now, remember, they've only taken, from what I can work out, they've taken line. That doesn't mean that it's been deleted, does it? Is that right? It doesn't mean that it's been deleted. The court has both inherent authority and rule-based authority. Weston Laura Loomer has been in her defamation suit against Bill Mayer. Oh, I'd like to see her in the. I'd like to see how she'd cope with that. Sanctions may include exclusion of testimony, striking the pleadings, adverse inference instructions, and egregious cases. The spoliation sanctions are appropriate. Minnesota courts consider the totality of circumstances, including the degree of fault to the prejudice to the opposing party, and whether a lesser sanction would remedy the harm and deter misconduct. Now, if you remember rightly, I don't ever recall seeing anything on Miranda or James's social where they have specifically called out without a crystal ball at all, or where they've discussed the case other than the fact that they were in a legal battle. I could be wrong. If I am, please let me know. On August 15, 2020, this litigation, and after receiving multiple targeted discovery requests, plaintiffs engaged in a wholesale destruction of presence. This was not selective document destruction. It was a complete obliteration of the primary evidentiary source underlying this. Plaintiffs admit that they deleted their TikTok and Instagram accounts in 2025. In their defective affidavits state, I deleted my social media presence as a result of the backlash from defendants' increased aggression this year. The deletions were immediately noticed and reported across all media outlets. I thought they were selective and they couldn't be used, but now they're trying to use what was in there. And now includes reporting that Derek's deleted their online presence. More than 3 years ago, defendants served discovery requests requiring the plaintiffs to preserve and produce precisely this material. On July 26, 2024, defendants sent a letter to plaintiffs noting that the discovery of potential social media content that might be relevant, asking for supplementation of discovery, including a full archive of Miss Derek's social media account information. Plaintiffs did not respond to the correspondence from Mortha Stavic dated July 26, 2024, and discovery closed shortly after there with no opportunity for original motion practice. These requests were appropriately tailored and encompassed exactly the type of material plaintiffs now claim justifies their defamation lawsuit. Plaintiffs were on clear notice that their social media content was central to plaintiffs. And again, don't start something, because remember, if you remember correctly, there are several things that the 7M and the Dereks and everybody wanted that allegedly had been deleted on Katie Joy's side. I'm just saying. This destruction was total, not selective. Plaintiffs did allege defamatory posts or remove specific content responsive to discovery. They eliminate higher social media presence, obliterating not just individual posts, but the complete evidentiary universe from which was preserved and produced. This wholesale destruction and every post, story, video, and image that form the basis of their public communications and reputation. Metadata. Critical timestamps showing edited, deleted, or modified. Evidence essential to the understanding the sequence of events and plaintiff's state of mind. Engagement data. Analytics showing reach, impressions, likes, shares, and saves. Data directly relevant to damages and the scopes of the alleged reputational harm. Interactive content. Every comment, reply, and response from followers, evidence that defendants correctly note is relevant to the issue of reputation. Direct messages. Private communications that might contain admissions, planning, discussions, or evidence, plaintiff's knowledge and intent. Contextual framework, the posting history that would allow evaluation of individual statements in context as required under Minnesota defamation law. The timing reveals intent. The August 15, 2025 occurred years after litigation commenced, when plaintiff's duty is to preserve was absolute. In targeted discovery requests for precisely this type of evidence. Immediately following the July 25 federal raid, that intent during ongoing discovery disputes about the scope of plaintiff's production obligations, plaintiff cannot claim ignorance. They knew their social media content was aimed at defendants' discovery requests. They knew deletion would prevent defendants from accessing material necessary to defend against defamation allegations. The prejudice is severe and irreparable. The destruction creates a... Now, I am also going to state that if it was there would have been a backup taken somewhere, and they would be able to produce that evidence. That would be the logic conclusion. But if they're really so... I mean, they could always ask the court to subpoena social media, Google and Meta and X and TikTok and all that. It's the other way to get the information. So you can get it still, even evidentiary defendants cannot access original relevant to the elements of plaintiff's causes of action, damages and analysis without engagement data and comment threads. Defendants cannot assess the scope of the alleged reputational harm or demonstrate that criticism was warranted. Malice evaluation, metadata and editing histories might disprove actual malice under Sullivan are permanently lost. Plaintiff's public statements, which might show pattern contradicting their litigation position, are no longer accessible. Comments from followers that might demonstrate public support for plaintiffs or might reveal limited impact of defendants reporting are gone forever. Media content is not peripheral evidence, it is often the central battleground. By destroying their accounts entirely, plaintiffs have made it impossible to access that Minnesota law requires. I would suspect that Amber is quite an intelligent lawyer, and so there would have been something. My gut feeling is that they're not just hidden. That would be my guess, if that can be done. This is not a case where a party failed to preserve some documents and inadvertently deleted relevant files. Plaintiffs systematically destroyed their pride in this entire litigation. Well, the same could be said about Katie Joy, but it would be like a products liability plaintiff destroying requests or a contract plaintiff shredding the agreement in dispute. The completeness of destruction suggests it was not designed to hide specific damaging evidence, but to eliminate defendants' ability to mount any meaningful defense based on the impact of plaintiff's social media presence. Now, I will also state that defense and everything in it technically would have already been before the court. Remember, you can't put new evidence into the court. So they would have been able to obtain all of that information at the time. If they're talking about in the injunction motion, they may be able to complain about that, but the original motion, they filed a defense to it. It's been, and so the original complaint that should have already have been defended and pleaded out also. Minnesota court routinely instruct juries that if a party intentionally destroys evidence, the jury may infer that the evidence would have been unfavorable. At a minimum, defendants are entitled to an adverse inference instruction, given the deliberate timing, scope, and severe prejudice. The court sanctions including striking plaintiff defective affidavits, precluding plaintiffs from claiming they lack notice of the investigation or related matters, awarding attorneys' fees for the destruction, limiting plaintiffs' ability to claim damages from social media-based reputational harm they himself eliminated. As I said, harm would have already been pleaded. Just saying. The destruction of evidence. The evidence is central to a defamation case. This stage of litigation, after clear notice of relevance, warrants significant sanctions to preserve and deter future misconduct. As I said, don't open a can of worms unless you want your. So I would have a feeling that, and talk about the missing evidence on the other side, this etc., etc., etc. Just saying. Plaintiffs have designated virtually every document in this case either confidential or these blanket designations are improper and inconsistent with both the protective order and the showing of good cause for restrictions. Party asserting confidentiality shall have the burden of proving that the information in question is within the scope of protection. Plaintiffs have designated entire deposition transcripts as confidential, including testimony that is not remotely sensitive. This sweeping approach deprives the public access to presumptively public judicial proceedings and needlessly burdens defendants. Defendants request that deposition transcripts be redesignated in their entirety, except for limited redactions narrowly tailored to protect home address, personal contact. Now, interestingly enough, if you also notice, her deposition has not been made public. So if she wants the defendant's deposition transcripts to be released, then I think it's only fair that hers are also released. Plaintiffs has also applied the highly confidential attorney's eyes only designation to nearly all the remains, including tax returns, financial statements, and ordinary business documents. Under the protective order, highly confidential is limited to information that is especially sensitive and private business information. It's not, wait on, including tax returns, financial statements, and then they're saying that under a protective order, documents should be sensitive and private business information, records, and personal contact information, and even then, only when disclosed party would cause significant harm. Use of attorney's eyes only prevents defendant Catherine Paulson from reviewing the very documents necessary to prepare her defense. Hang on, is she or are her lawyers preparing her defense? Because if her lawyers are preparing the defense, why does she need to see? This is untenable in a defamation case, where Katie's knowledge and context are to evaluating the meaning of the challenged statements. Courts routinely recognise that AEO designations must be used sparingly and cannot be a litigation tactic to hamstring an opposing party. And don't forget that if all of those financial statements, if all of the documents are released and taken out of the protective order, fair that all of her documents are under the same thing. They're not going to say the different documents are now going to be open slather and the plaintiff's document. If she saw that the minute she had any of that information had been correct. Well, look at the marriage stuff. Plaintiffs argue that listening designations would enable doxing. That argument is unfounded. Defendant Paulson has never disclosed private addresses or PBI up to discovery. Reporting based on publicly available sources, corporate file content, plaintiffs themselves chose to publish. They didn't choose to publish the marriage record, the marriage stuff, did they? The protective order already protects. When a plaintiff seeks, he is not protection from doxing, but insulation from scrutiny. They are attempting to prevent the defendant from reviewing and contextualizing the very evidence she is accused of misusing. That misuse of designations is inconsistent with Rule 26 and the protective order's plain language. So here's my thing. If they want their requested relief, this could backfire on them, because if they want the deposition transcripts released, I want to see her deposition transcript. Defendants respectfully request the court order as follows. Deposition transcripts shall be de-designated in full, with confidentially limited only to personal contact information, home addresses, and other PPI. All attorney eyes only designations shall be removed. Documents such as tax returns, financial statements, and other businesses records may remain designated as confidential, but must to defendant Katie Paulson to enable her to insist in her defense. I don't know why she needs to see. I don't know why she needs to see some of this. As I said, if the lawyers are preparing your defense, they would be able to say, we've got such and such an information. But anyway. They've sort of given it away that she's writing her own documents. Where was it? Here. Prevents defendant Catherine Paul reviewing the very documents necessary to prepare her defense. Have they just admitted that she's writing all the documents? I don't know. Well, that's right. That's what I'm saying. Why does KJ need to see it? These are the ones making the arguments, not her. Well, because I think there's been a few people suggest that maybe he's writing the documents and the lawyers sign. Plaintiffs bear the burden of proving that any future confidentiality designation is supported by cause under Rule 20 of the Protective Order. Conclude. Plaintiff's motion is not only unconstitutional, it is unsupported by competent evidence. The recycle unsworn assertions and hearsay while withholding the very discovery this court ordered. Far from establishing the right to injunctive relief, the revelation of key evidence undermining the truth-seeking processes and prejudices defendants' ability to defend themselves. The First Amendment does not permit the prior restraint. The law has already rejected relief in this case. Plaintiffs cannot satisfy a single Dalberg for no likelihood of success on merits, no irreparable harm, and no basis for this court to assume the role of censor. Their request is for relief. It is a misuse of judicial process designed to push lawful criticism and obscure their own misconduct. The court shall deny them entirely and do so decisively to foreclose any attempts to weaponize this litigation against protected speech. The undersigned hereby acknowledges that cost disbursement and reasonable attorney and witness fees may be awarded pursuant to ministry. And all right. So that was 23 pages. So this is what they're asking the court for. So this is a proposed one that the plaintiff's motion for temporary injunction is denied. The affidavit is stricken. The plaintiff's memorandum of law is struck. As a sanction plaintiff spoliation of evidence, the jury trial, that it may draw adverse inference that the social media defendants be awarded reasonable attorney fees. All right. So now we have 116 pages of evidence. I am a licensed attorney. Yep. Right. So we've got an unpublished Minnesota authorities. We've got article new evidence here about we've got the new evidence about the raids and the social media posts. We've got cross deal to order documents. Then we've got stuff in here about from California case. As I said, I don't believe that they're technically relevant. and the correspondence. So, as I said, they're saying that they've put that thing there, and it just said, I'm not going to go through all the 100 and whatever pages, 116 pages there are. Okay, but that's their case law. So that's essentially what's been filed. Now I'm just going to have a look to see what Miss Balls may, because I think stuff on social media. I did read one of her posts that says that she won't settle. Oh, Miss Balls has actually. Oh, Miss Balls is already onto it. Okay, so let's have a look. So I'm sharing these screenshots first, as they will be needed to point out Katie Joy lying under oath, twisting the truth, and completely rewriting history. Y'all, this is so bad for her. Her filing is an auto pen chat TBT rambling rage fuel mess said. So here the affidavit. So it's further your affidavit saith not. As I said, I don't know. So she wrote that, and then that. This discovery Robert Shin provided me in court assets and business contracts. It proves Miranda Derrick has no control over life, marriage, and finances. I hope the feds raid his. And this is based upon another legal signatories of Miranda Derrick. We're 90% confident of her signature is forged. Remember that? And then it said that the court also, any discovery disputes shall be brought by further motion. So they had to file another motion. So, yeah. All right. So as I said, no, these are the affidavits. These are right or not. Verification upon that. I declare under that. Yeah. All right. This is the affidavit. As I said, I don't know. Okay, so, all right. So then we've got, so that's what, there are 23 pages. Miss Balls is implying that she's using ChatGPT. I want to add that KJ lies about discovery deficiencies because the judge will have stated motion, correct? There was something else that I saw. So here. Yeah, it's just all very interesting, isn't it? That's what they're looking for. That's what they're hoping to get. All right, Miss Balls. All right. Then, as we've reported, extensively defending oneself from negative publicity is not retaliation. Blake created the Springer team to defend himself is not an employment retaliation period. And remember, she's also stated, Amber has enabled Robert Shin by refusing to withdraw his lawsuit against me. She's helped him routinely retaliate against me, and in my opinion, my opinion of it treated me during my deposition was horrific. Also, years because of her health issues, which had nothing to do with me or the justice I'm deserved. Sick, you give the case to another attorney. You don't drag the opposing counsel and client through delay after delay. Then tell us last week for daring to bring that up that it was her refusal. to recuse herself that has delayed this case for 3.5 years. That's my opinion, and I have the right to share my truth. Robert and his attorney, he's on investigation. There is no dispute, and I'm not that bad ones here. These are my opinions. I'm sure Amber will seek sanctions against me for staring. And this was, remember, Amber had asked because she had breast cancer. Now, the other thing is that Amber was the only lawyer at that time. And then she says, you can't, W is accusing cancer as an excuse. Remember when the excuse for failing to attend a deadline was Graham's mother, and this one says, defendant's answer, but failed to serve and file it. The failure had two causes. First, counsel was anticipating the court would issue an order. Second, the counsel was unexpectedly called out of the office when his mother-in-law became ill before he could properly. And then we had, as our office completed the answer and intended to file it and serve it that week. Also that week, my father-in-law, who had been in intensive care unit since August 5, took a substantial turn for the worse, requiring multiple visits per week from my wife. This left me home with a 5-year-old. So remember, they couldn't get their own facts straight. Now, I am fighting this lawsuit to the end. I will not settle. I will not be silenced. Every settlement being pushed into came with one condition: my silence. And I agreed to stay silent, never again. This fight is not about me. It's about victims who have been by Robert. It's about people who lost their voices. I refuse to abandon them and let their stories be buried. This fight is about standing up for free speech. It's about showing every reporter, every whistleblower, every survivor or power someone has, they do not get to bully and intimidate us into silence. It matters. I'm fighting because victims matter, and I'm fighting so no one else has to feel like silence is their only. Robert Shin and Associates will not win. I will not be intimidated or silenced and painted. I'm sick to death of seeing his minions make video after video painting me as a danger. You know those videos. You know the creators. They feel they are fighting a righteous fight for Robert Shin and think Miranda Derrick is hanging out with a 68-year-old man giving up her entire career for fun. In hope every single creator that helped him is somehow held responsible. I will not be silenced. The victims in this case matter more than any amount of money in my bank, to inspire others not to bend to bullies, to fight for what matters, and refuse to bend to YouTube politics or dog piloting. So then this is I have the right to report and speak my truth. Robert says I can't call myself a victim of him. Why can't I? He says it's defamatory. I've spent $200,000 on this lawsuit. I have. It's defamatory to under investigation. He is. In the past 2 weeks, many of you stopped following me because I refuse to pander to rage baby and fear. I will not promote misinformation when I know that this is what exactly Robert does. It shocks. Can trust my reporting on Robert Shin and other malignant personalities, but believe I'm somehow lying about fear-mongering and conspiracy theory. Consuming content that rots your brain and convinces you that a president's wife is a man when verifiable proof is everywhere in form on the same platform and defend men who sex traffic and abuse. I'll never align. I've dedicated my work to victims of sexual abuse and exploitation, and thinking I'd be cool with women who defend abusers. You don't know me. Andrew Tainstein should not be defended ever. I'd rather stand up for truth than get rich promoting lies. What about a distless regard? Oh, here we go. We've got more. Imagine this. You're a reporter being sued by a man under federal investigation. There is no dispute. There is a criminal proceeding actively occurring against Robert Sheen and his associates. Then his attorney has the audacity to file a 20-page motion accusing me of harming his reputations by spreading false and defamatory statements that he's under federal investigation for sex trafficking. This is exactly who Davik is, and the kind of unethical lawyer. I can't. She's actually having to go a lawyer now. Can't imagine helping harm on reporters and file false documents willingly in court. That's a very big accusation, in my opinion. During my deposition, Amber's lied from the claims in this case. She suggested I was an alcoholic, challenged my fit applied to child abuse. None of this has any relevance to the merits claims against me. It wasn't about fact or evidence. It was about a character assassination. Robert sat through all, seemingly engaging her tactic, effective advocacy. It's an abuse used solely to humiliate a defendant for Robert's personal vendetta. After 3.5 years, I'm done. We are seeking sanctions for the repeal, and I'm done with their intimidation. I have rights under the law, just like Robert. In this case, my rights matter more than his right to continue. That's a Luca. Come fight me, Luca. So yeah. Oh wow. Let's look back at why Amber is Katie Joyce states as fact she was arrested, called Shirley a monster, and people left hate comments. So she says, finally, I'm screaming from the rooftops that finally law tries to arrest Robert Sheen. Remember, he was never arrested. All right? That's how you do it. Thank you, FBI. Any victims trapped inside, those have left. Shirley Kim, you're a monster. I watched you control Miranda and James during their depositions in your lawsuit against me. I watched Miranda and James appear terrified to answer questions, even playing dumb and lying for you. You had every opportunity to know it was wrong and didn't care. I hope you rot in prison. So now she's accusing Shirley Kim. The feds got him. He's finally going to prison. Where does it say there in that documentation that if a reasonable person would assume that Robert Sheen's been arrested and is in prison? That's what a reasonable person would assume, which is incorrect. So this is Miranda. I heard the good news about your boss's house getting raided. Good luck in jail. So then she says, Robert Sheen's attorney claims there is a parallel criminal proceeding to a civil case in California against me on September 17th, stating it was defamatory to report that he was under federal investigation. Here's the thing. It wasn't art that they were complaining about. I love. Yes. See, Miss Balls, she's got it. I want to add the motion filed was under investigation, but it had to do with Katie Joyce stating as fact that he was arrested and she wanted him to die in jail. So it was never about, and that is being missed here. It was never about what they said it was about. It was about the fact she was stating this fact that he was going, or that he had been arrested. That was this. I apologize for my background. I've lost my virtual background. So, yeah. And you know, they're really go. She's going. So Miss Balls with all the evidence. So thank you about that, Miss Balls. So I can't make a comment about whether the affidavits are. I tell you, and I know whether they're. As I said, I do know that sometimes happens that they will file placeholder stuff in to meet the proper ones get filed after. Sometimes. Oh, you've got my hair has gone long. What is it? It is nearly 11 o'clock here, and I've had my shower, so then it's not going to affect me when I go to sleep. So, yeah. All right, I think that's about for tonight. So we've done that. So we did that on and try and go through all of that. I apologize for the sound. I think it's just a pain. Australia's internet's pathetic, to be honest with you. So you know. Yeah. So I'll be back, I guess, sometime. But anyway, thank you all for watching. Hopefully we've looked at some stuff. I still haven't used the word at bottom in that document. And I hope you enjoyed. I tried to make it a little bit more exciting. I probably do, actually. I probably do. I haven't done one for a while. I haven't done one for ages. But the thing is, planning, that like doing it, it's all been like I've been doing it all every week. It's still going. This is October. See? This was September just had. So you live in the country, yeah. So yes, I've done all of that. So there you go. Start of October. Whoops. Just lost what's in there. So yeah. I have been doing it religiously. So I to film. I actually find it very therapeutic at times. So I will just often sit here when I should be working and stuff. And yeah, that's what I do. You live in the middle of nowhere? Yeah. Video or it didn't happen. I know it didn't happen. Yeah. What have I got to do tomorrow? It's Wednesday. 1st of October. My birthday's coming up, actually, which is another year. And I actually got some really cool stuff, some really cool stickers from Temu, believe it or not. Look at those. Yeah. So. All right. Well, as I said, I want to thank you for watching. Thank you if you could hit like and subscribe. And yeah, help get this video circulated. I'm using Stream will probably divide this video up into little shorts. There'll be a whole pile of shorts that come up. And yeah, as I said, my internet's not good. So yeah, I know. Maybe I need to change my thingos a bit. Yeah. Ooh. Customization. I need to have a look. They've added some new stuff in here too, just for a bit of fun. Yeah. Anyway, as I said, thank you. Oh, there is a count. Didn't realize that. Well, there you go. Oh, to play with in here. We might have to try that next time. as I said, thank you for watching. And I will catch you next time. Until then, look after you. Bye. Oh, hang on. Do this. Thank you for watching. And bye for now.